and speak to this matter, considering our guys from the Moyoi community who are the Maasais, and the other communities that live around there, irrespective of whether we represent them or not. Because otherwise then, Chair, the committee might descend into everyone trying to defend the people that they actually represent, which is also their right, but to try and resolve it. But my question to the PS, and he's actually right, that the ministry does not keep a register of evictions, whether they happen or not. But PS, sitting where you sit, and then they'll see where you sit, representing Kenyans, doesn't the government have the machinery? Because we're talking about the government, we're not talking about the Ministry of Lands. We're not talking about your specific Department of Lands. And when you are here as a PS, you're actually representing the government in whole. Doesn't the government have the machinery to determine whether the evictions did happen or not happen? You having the records notwithstanding. That would be the question. If someone came to your office and told you that they have actually been forcefully evicted, he's saying that we do not have a record of such eviction sufficient, according to you, without consulting your larger government arm to find out whether such evictions really did happen. And my answer would be that it is incumbent upon you, PS, to find out, even from the Ministry of Interior, the government has machinery to the ground. Because the Ministry of Lands, the government, I don't want to talk about Ministry of Lands, because you're here representing the government. If you speak to the Ministry of Interior, and in their report, they will tell you that that eviction did happen. So it is actually wrong for the PS representing government in this session to say that he doesn't have the records. Whereas he's a PS of a section or whatever, but he has, it is up to him to find out from other relevant government agencies, did an eviction happen? And I'm sure if he did that, he will be able to essentially find. Number two, Chair, on this matter, when you look at it, NLC, and that is now my next question. When you make a determination as NLC to try and bring people to where they actually were, and maybe your decision is actually challenged, representing Kenyans who sometimes are ignorant of the law or who don't know what their next step is, because when people have come here for petition, we cannot now start saying, oh, they should have challenged it in court and things like that. The reason why this committee actually was set up is to try and help Kenyans. Many of them who come to us don't even know the procedures of what essentially needs to happen. So I'm asking NLC, when a determination that you're convinced was the right determination was done, and it has been challenged in court in a case where you are also participating, why is it that you people have also not appealed to defend your own decision? No. Order, my friend. Yeah, order.
You are making a lot of noise.
Yeah.
Yet I am here to give you an opportunity to speak when you need to.
Yeah. So when NLC makes a determination, and the CEO is here, and it is challenged in court, your determination is actually made in court. You are also government, and you think you made the right decision. At what point do you consider it necessary as a commission to also appeal on your judgment? Thank you, Chair.
Honorable Marius.
Thank you, Chair. Chairman, we met here for this petition, and I'm happy that today we are here again. The CEO of National Land Commission is here, PS for Lands is here, and many people are here watching. Chairman, when I entered here, I found the PS speaking, and he said it clear that they don't deal with historical land, it is NLC. And Chairman, if it is NLC which deals with historical land, and I can say it here again, 2019, NLC did their due diligence following extensive hearings and awarded that land of 20 acres to people of Korea. Chairman, it is very bitter. When you see people dying on the same land, people of Korea being evicted from the same land. When you were here, you can remember one of them standing here and said he was shot 8 times. And still on that land. Just recently, when today I hear PS saying that he's not aware of any religion on that land, I get shocked. I can tell you, after that petition we were here, many people from Korea again have died in the top record. Many have been injured in the same land. Nature said people have titles. Can you find out when these people got those titles? It is after, with the influence. Because he's here, as Honorable Yanita said, representing government. We are serving in the same government. Sometimes we get shocked in the government we belong. Today, our people suffering. It's very bitter. Chairman, I decided to come here because I serve people of Korea who today, if sometimes you watch, you can sympathize. We have talked to the president to sort this. Personally, I've talked to the CS of Interior many times. I've talked to the Inspector General, sympathize with the people of Korea to go and sort this matter. I've talked to the PS who is in front here. We have met in his office, and even one time I went to the retirement and we said, see how you can sort this matter. People of Korea keep this. Can live in peace if this government decides to intervene and solve this matter. But you see, when we raise these complaints to be sorted, nobody hears. But we find that one side is being favored, being supported by policemen who authorized to go and assist to evict people from that land. And I can tell you today here, we are all human beings. It's good that the CEO of National Land Commission today, she's here. The PS is here. People of Korea are suffering in this government, under hands of government you are serving. With the truth, who owns that land? People of Korea are the owner of that land. And if NLC made a decision and later on things changed, you can't tell what happened again. So the CEO of National Land Commission is here. I know she has a report to tell us here, but what we are praying is that let us sort this matter and the people of Korea get their land. Thank you, Chair.
The National Land Commission what do you have to say about the issues raised? And not forgetting the issue that was raised by the volunteers. The issue raised by the Honorable Mark Namita is an issue that you will need also to respond to. But let's also allow Madam CEO to respond to the issues raised by the Honorable members.
Chair. Excuse me, Chair.
Do you have the responses with you?
Yes, Honorable Chair.
Have you shared them?
Yes, Honorable Chair.
Okay.
Honorable Chair.
Go ahead. Yes.
Yes, we never said on our question number, I think that's the right time to change it.
Okay.
Chair, I wanted to know what the National Land Commission considered as historical injustice when they awarded the tender people 20,000 acres.
Let's allow her to respond first, and then if there are questions, we will ask or interrogate.
Thank you, Honorable Chair and members.
Chair, we don't have copies of our response.
Do you have more copies with you? Please share. Proceed.
Thank you, Honorable Chair and members. Listening to PS submission, it's like he summarized my presentation this morning here. If you allow me, I can read through the written submission. Thank you, Honorable Chair.
Start on the response.
Yes, I think for the sake of honorable member who asked what did you use as a measure to give the 20,000 acres, allow me to read through the petitioner's claim. The petitioner's claims, represented by Munyonge and Anahaki, a welfare association of the Kuria people residing in Migori County, had raised concerns regarding their historical occupation and subsequent displacement from the area known as Moyoi, Escotura in Transmara, Narok County. They claim that the Kuria community are the original occupants of this land, with their presence predating the arrival of the Syrian Maasais in the 18th century. The petitioners assert that the Kuria people lawfully paid the 20,000 acres of land in the 1950s, pursuant to the colonial era agreement, that these rights were found through historical documents, community testimonies, and court-supervised settlements. They said that on 2nd February 1989, the community was subjected to a forceful and violent eviction by the government, security agencies, resulting in the displacement of over 13,000 people, destructions of homes, loss of properties, and severe human rights violations. The petitioners further indicated that the National Land Commission considered the matter as historical land injustice, and after extensive hearings, issued Gazette Notice number 1550 of 1st March 2019, awarding the 20,000 acres to the Kuria people and recommended restitutions while integrating current occupants. The state, however, that the implementation of these regulations has tolerantly due to the interfered by private developers and uncooperative local administrators. Those are the claims. They add that the continued impasse has undermined intercommunal peace along the Transmara border, and that unfounded allegations suggesting an intention to alter county boundaries have further inflamed tensions, despite the clarifications that they seek restitutions only. Not boundaries alteration. The petitioner said that the prolonged displacement has forced members of the community to live in informal settlements without adequate housing, access to land, or meaningful livelihood opportunities. This is in violation of Article 40, 43, 63, and 67 of the Constitutions. The petitioners therefore sought the intervention of the Public Petitions Committee to address their irregular acquisitions of land to implement the NLC determinations issued in 2019 to to cancel irregular titles, preserve the area, and facilitate verifications, settlement, and compensations of all affected Korean families. The petitioners began the community field a historical and injustice claim with the National Land Commission in the year 2017. The Commission received and admitted the claim and assigned it as historical and injustice claim under NLC /HL line /01/2017. Our response to this, Honorable Chair, is that the tender community claim that they were evicted from their Agata Baragoi and Moyo Education Center in 1989, from where they have settled since 1945, after exchanging livestock with Syria clan of Maasai for land in an agreement witnessed by colonial government. That's Narok Maasai Elder and Kono Kukuya Elder, and the Narok DC then gave them a license to occupy the land. But after independence, the provincial administration bought their houses and evicted them in 1989. The area has since been adjudicated and registered as Angata, Baragoi, and Moroi registration sections. The Commission proceeded to hear the claim under Article 67(2)(e) of the Constitution and Section 15 of the National Land Commission Act. The Commission also invited all parties for the hearing, but the response from the Chief Land Registrar, the Director of Land Education and Settlement from the Ministry of Land, and the Narok County Commissioner did not appear. After hearing the parties, the Commission proceeded to issue a determination 7 February 2019, which was gazetted on 1st of March 2019. So that's how we arrived at the determinations. The Commission's mission was in the following terms. One is titles from the two education section of another Baragoi Moyoi be revoked and dedicated to accommodate all the communities, including the Tende community, especially on the part of the land that is unoccupied. The occupant, the claimant Tende community need a institution as stipulated by NLC Act 12, Section 59 B to Area C, but with integration of the current land occupants. Looking at the court judgment, aggrieved by the decision of the Commission, the respondent here in Angata Baragoi farmers, 243 others filed a court case, Narok EAC petition 6 of 2021. And the court in its judgment, which was delivered on 27th of February 2025, ordered as follows. 1. Petition number 623, 2 and 3 of 2021 be merited. Environmental Affairs and Environment and Land Court at Kilgoris Environment and Land Decision number 8. A file, I think, with attached an annex under Register 1. Be a declaration be and hereby made quashing the first respondent's determinations under the claim known as NLC /HLI/019/2017, pronounced on 7th of February 2019 and published in Kenya Gazette Notice of 1550 dated 1st of March 2019, recommending the first and the third interested party to cancel and revoke all ownership documents for Angata Baragoi registration section and Moya registration section. A permanent injunction be administered by year issued prohibiting the first and third interested parties from implementing the quashed determinations by the first respondent in the proceeding referred as NLC /HLI/019/2017 in regards to the petitioners' ownership documents and generally all titles issued in Angata Baragoi education section and Moyo education section. 4. The petitioners in petition number 4 of 2021 violations regarding the fair hearing under Article 47, 48, and 50 of the Constitution. Each party, of course, to bear their cost. Honorable Chair, the National Land reiterates its earlier recommendations on the Korea Community Historical Land Injustice, formally published under this 2019, and involved explicit court orders, including the quashing of the 2019 determination and the permanent injunction prohibiting the implementations of the Commission is bound by the order of the court. Honorable Chair, therefore the Commission remains fully committed in supporting the lawful redress of the historical land injustice across the country. Maybe you also make reference to Honorable Nyamita's comment, what NLC can do about this. We are only enjoying as an interested party in such case where we don't have explicit interest in the matter, because we have had the matter, we have determined, we have delivered our determinations, which has, however, been quashed by the court. So therefore, as my peers said, haki ana mnyonge ana haki, who are in court actually would have appealed them. Then for the rest of us, ourselves and the ministry to be joined as interested parties. Secondly, if in the absence of us being enjoined in this case, because we did not file an outright appeal against the decision of the court, we are now open and we want to thank the House, members of Parliament, for actually reviewing our NLC Act, Section 15, which has given us a continuous power to hear historical land injustice. So once the commission is fully constituted, we are not fully constituted currently, then we will also ask them maybe to resubmit the claims for further review. Thank you, Honorable Chair.
Thank you, Madam CEO. Now, on the issue of extensively listening to the stakeholders, did you listen to the, is it Moyo here? Did you listen to Moyo?
Thank you, Honorable Chair. I think from the submission it's clear that the parties who are not present, which is largely on the administrator side, and our officers from the ministry, so probably in the absence of that, then the matter is not fully heard. And we have one of the members say that the administrator actually know who has been evicted or not. Then in the absence of this, it may not be adequate information for us to make a decision on this. Probably there will be room for further review. Thank you.
So, how did you make a determination of a piece of land? When you said that you had a petition as extensively, yet you did not go further and find out whether the land in question was occupied, or you did not seek to listen to those that were occupying the land, then can we really say that that matter was extensively dealt with?
Thank you, Honorable Chair. I have Edmond Gishuru here, who is the head of historical land injustice. Before we make a decision, these are technical team who visits the ground and advise the commission on what happened. Probably you allow him to share the experience. Thank you.
Go ahead.
Thank you.
Please respond, please, question.
Chair, I would want to ask NLC. They have mentioned that the parties did not come. Did you expressly invite both parties? Two, you mentioned that there was unoccupied land. That is where you based your determination to settle the historical injustices and give the Kuria people the 20,000 acres. Is that what you said? Thank you.
Go ahead.
Thank you, Honorable Chair and Vice Chair members. Whenever we actually take time, but on the allocation of the land, I think it's explicitly indicated here that there was 20,000 which the community bought. So likewise, given a time, I think if you can give me time, I can be able to confirm whether we have these 20,000 acres available or we based on the documents submitted by the Kuria community when they bought this land in the 80s. Thank you, Chair.
Let's allow that gentleman to submit first and then we come to more questions. What is it, Honorable Okesh?
Chair, there are three submissions that are very wanting, given that I've also been very involved in this Korea issue. Chair, the CEO of the Commission has said that given the court determination, basically the Commission find is hands tied. They can't take any action. Chair, the court decision was on the determination of LLC. And LLC, constitutionally, if you look at Article 253, incorporation of commissions and independent offices in Kenya, because there was even more authority than even state departments to run independently. It says each commission and each independent office is a body corporate with perpetual succession under seal. 2, is capable of suing and being sued in its corporate name. If a court has questioned your decision, why do you want to put this burden on the Kuria people to go back to court to appeal? It is your responsibility to go and defend that decision. That's number one. And I would wish that this particular committee makes a determination on that aspect of the commission's lack of decision to actually engage the court on this matter. The second issue, Chair, is on what the Vice Chair has asked. The Vice Chair has asked whether all those other parties were invited. But actually, the Constitution gives the Commission the power of not only inviting, it gives the Commission power 252 of the Constitution, general functions and powers of the Commission. It says the following have the power to issue a summon to a witness to assist for the purposes of its investigation. The number one commission is Kenya National Human Rights and Equality Commission, the Judicial Service Commission, and then the third one is the National Land Commission. So why is the commission giving burden to people of Kuria who are already overburdened by this issue? They don't have their lives going on. Why can't the commission do its job by issuing summons, concluding that investigation, and then challenging the court decision on its own decision? Chair, this is a question that must be answered.
Yes, Honorable Okech, your issues are very, very important and should actually must be answered, except that we would have waited for that gentleman to make his submission, and then let's give the gentleman an opportunity to make submissions, and then your questions will be answered. Please go ahead. Mheshimiwa, kindly hold on.
Today you say I'm unreasonable. The first time I've been called that. But I wanted to ask you to be a bit fair to us, because we were dealing with that witness. And we wanted to ask questions on her, because she has said some things which need...
The witness you're talking about is the National Lands Commission. And the officer that we would want that he makes his a remark is from the National Lands Commission. So let him inform you more so that you will ask more questions.
Yes,
Honorable Vice Chair.
Honorable Vice Chair. Let me make this statement. I think if I heard right, the CEO requested his officer to assist her, give some information. So let's give them time, because it's the CEO that actually requested that that officer makes further submission on what she was trying to answer to the members. Thank you.
Yes, go ahead. And Madam CEO, please take note of the questions raised by the Honorable Senator.
Thank you, Chair and honorable members. The question by the Vice Honorable Chair on whether we invited all the parties. We did that as a matter of fact, and not once. We always invite parties for these hearings via written letters of invitation, and we use our county offices to reach out to the parties. We also call these parties for purposes of these proceedings, and so they were invited, but unfortunately, if you look at the determination of the commission, there was a finding that despite the invitation, they didn't participate. And again, the court was able to make a finding that, as a matter of fact, the commission did not demonstrate that we invited all the parties. But to answer your question, yes, we do invite parties for hearing touching on historical land injustices. On the issue of unoccupied parcel of land that has been referred to in the decision or determination. One of the things we do, because this is an investigative process under the law, Section 15 of the NLC Act and Article 67(2)(e, we have to do ground visits. We send our technical officers, and they include an array of technical personnel, surveyors, land adjudicators, so personnel who have technical skills or settlement skills and adjudication of parcels of land under the Land Adjudication Act. And they were able to establish that there's a portion of the land that is the subject of this dispute before the commission was unoccupied, and that was the basis of the finding that was made by the commission. I think those were the two questions that Madam CEO requested I respond to. Thank you, Chair.
Yes, Honorable Sumbuli.
Mr. Chair, I know you are a fair man, but you can see that there are very many people from the Godi here, and I'm the only one from Narok, so for heaven's sake, I will require a little more intervention, because my clients are...
No, Chair, that is out of order. We are here representing the nation. We are not here representing respective counties.
I wish the comments would reflect that. But Mr. Chairman, I wanted to ask a question. Because the Honorable Senate has made a serious indication that says you should rule over it. And please do. When you appear before an authority that is doing something akin to quasi-judicial, that is making a decision, like your committee now, like the NLC, that is a tribunal. Do you expect in the law of Kenya that tribunal will appeal against its own judgment? There are aggrieved parties that approached the NLC, and it was up to them to go to court if they were aggrieved. Secondly, and I want you to make the decision, actually we shouldn't be discussing about the decision of NLC here. It is moot. I wish there were some more lawyers here. The decision of the NLC has been taken to the court of competent authority and has been pushed. It doesn't exist, so to dig them again and ask them to explain to you how they did it. But now that you are there, let me ask them, Madam CEO, who were the commissioners of the NLC who had this dispute? And who are the technical officers who went to the ground? Is it true that this decision of NLC was influenced by a courier member who was there, and that there was nobody from Narok County or any part of Masailand who was hearing the case? And is it true, therefore, that now that this case was never heard, because cases are never heard by listening to one side? Because I was going to make in my submission a request to you, Mr. Chairman. It is clear you called the Tende community here without the Maasai community. You had them in their absence. The NLC called called these other people without hearing them. Isn't it fair now that you actually rehear this matter?
The Honorable Sumbuli, when we called the Tende community here, we called them here because they were the petitioners.
So are you going to call the other side?
If they write to us to be heard, we will listen to them.
No, Mr. Chairman. But how are you as a committee going to to determine a petition, even if they don't apply? You have the powers to know, to say who are the other side.
The Honorable Sumbuli, we are in the process of doing a report and finding out exactly what is this petition about. So if there's going to be a need for us to listen to the other stakeholders, we are at liberty to invite them, or rather they are at liberty to write to us, and we will grant them an opportunity to be heard.
Or the other way.
But there was nothing, the Honorable Sumbuli, there was nothing wrong with us listening to the community, because they petitioned this committee, and it is our duty to listen to the petitioners when they do that.
All right, so how do you determine an issue like people's land being called empty land? Because Mr. Chairman, let me say something so that I stop talking.
Okay.
Mr. Chairman, I would like to invite you to invite the people who live on the land. Number one. Number two, that I would like you to make a determination that this matter has been heard by a court of competent authority, and that this matter has been fully determined. Number three, in your invitation to me, you say that the purpose of this meeting is to reach consensus on measures to address the prayers sought by the petitioners and the insecurity in the region stemming from the land conflict. Mr. Chairman, unless the intention of this petition is to cause insecurity, there has been no insecurity between the Maasai Syria community and the Korea, not even cattle theft. So, this is untrue. Apart from the little problems we have had in Nyanderema between the Kipsigis and the Korea, which the Committee for Security has adequately addressed, the rest of the border, including Honorable Roby's place, has had no problem. So this issue is a very, very... Let me finish, Vice Chair.
Chair, is it right for the member to cast aspersions on the committee on the issue of security? We are here.
No, I think, Madam Chair.
Vice Chair, you are on the floor, Vice Chair. Continue.
Yes. Because it's not right for him to cast aspersions.
No.
We are here to listen. And also, Honorable Chair, the member should also realize that we invited him as a friend of this committee, and he should be able to listen, to have an hearing for everybody. We are a very fair committee, we need to listen to you, and when time comes, this petition was brought by the Korea people. Once we are done, and to the Speaker, they wrote to the Speaker, to Parliament, they petitioned Parliament, and Parliament, through the Speaker, gave this petition to this committee to listen to it. That is why we invited the petitioners to come and make their submission. At this moment, we are at the stakeholders. That is why we have invited NLC. That is why we have invited PS. That's why we have invited CS Interior to come as stakeholders. And we will also, at a time appropriate, if we need to invite the other party, or if they request, we will invite them as stakeholders, and we will listen to them, so that before we write our report. Thank you, Chair.
Chair, please, your hand up. Chair, just
yes.
point of order, Mr. Speaker.
The Honorable Sunkuli was also on the floor. Let him finish.
Yeah, but it is a point of order on his submission.
Yeah.
Point of order on his submission, Mr. Chair.
What is it?
Chair, there are two issues. One is claiming that people from Migori are many. Who stopped him from inviting people from Narok? Two is questioning the authority of NLC. The NLC is an established body with the authority to summon. When you summon you and you don't interfere, you don't appear. What next? Did he want them to arrest those people to come to them? Now, you invited people to come to this meeting. If somebody decides not to come, it is allowed in law to proceed, because the NLC need just to provide us by evidence that they invited these other parties with through letters and whichever communication, and they didn't appear. And the right of these other, the Korean people, they were seeking their right. So they can't stop seeking their right because other people have decided not to appear.
I'm curious to know whether NLC has any evidence showing that they had invited the Moyoi people. Do you have any evidence?
Yes, Honorable Chair.
What evidence do you have?
We can provide the letters of invitation that we did. We did carry them with us today, but should you give us...
Were the letters acknowledged by the Moyoi?
So the service was... so in terms of acknowledgement, in terms of any written acknowledgement, no. But the delivery of the letters was done, or the invitation was actually done. So, but we're able to provide whatever evidence we have in terms of written documentation.
You know, you can have a letter of invite and keep it with you, and it doesn't find its way to the people who are supposed to receive it. So is there any evidence to show that indeed these people have been invited and it is only that they didn't show up?
Thank you, Chair. We did letters of invitation. I understand your concern on that. Ordinarily, what sometimes we do is we request for affidavit of service, so that the parties who we request to do the service. So sometimes the Commission will order the claimants to serve the respondents. Where there is difficulty, the Commission does the actual service. And what we do, we use our county offices to reach out to the parties in the county.
To whom did you address the letters of invite?
So what happens is when we receive a claim, we identify the respondents. So all respondents are invited for any proceedings touching on a claim that directly or indirectly affects them.
Chair, just to some point of
Yes, the Honorable Sukulu, it's true, he was on the floor.
Yeah, Mr. Chairman, I think the better answer is that the court anyway found that the others were not served. They were not invited. The court made that decision, and that has not been appealed against. And I was just saying, Mr. Chairman, I will request, if this request will be heard by you, that you hear this matter like a court should hear it. Just invite the other parties to come and listen, because even other men, if were not condemned without hearing, you don't just invite the Maasai people, invite the Kipsigis people to come to this petition committee so that they can be heard. And you must also bear in mind the fact that the colonialists set up provincial boundaries, and that the true home of the Luo, the Kuria, and everybody is in Nyanza. Apart from those who have been given land in Osinoni, the rest actually belongs to Osinoni. So this commission should actually go and determine on the ground where are the boundaries between Nyanza and Rift Valley originally. Because, Mr. Chairman, it is also relevant for me to say that this is the
point of order, Chairman.
No, I want to finish. That's not the Chairman.
Point of order.
What is out of order?
Is the honorable member in order to say that if you come from Nyanza, you must own land in Nyanza?
Maybe
does it mean people of Kuria cannot own land or Rift Valley?
The Bible says that you should not covet other people's property.
Now,
and homelessness.
The Honorable Sukuli, the Honorable Matthias was on a point of order. I'm shocked that you decided to answer for me. Yeah, it was not for you to answer.
Today you're very hard on me, but
no, I'm being fair to you and to everyone.
Okay.
Yeah. So the Honorable Robbie had a point of order, and I think any Kenyan can have a piece of land, can own a piece of land in any part of the country.
Anyway, but the one that is being described is our land.
What is it, Honorable Engineer?
Is it fair for the friends of the committee to hijack this meeting?
That's a very good observation, that the friends of the committee are behaving as if they are not truly friends. So kindly make your submissions, finish and give other people a chance to make theirs in silence.
Mr. Chairman, I'm sorry, I'm not really a noisemaker normally. It's just that I'm finding myself in a situation where the procedure here.
You must restrain yourself henceforth.
Mr. Chairman, this is a very emotive issue. It is a petition which I would say is a bit mischievous but very dangerous. Because even you, as you sit as a committee of the National Assembly of Kenya, these famous stories that you want to send Kenya back to factory settings and say, where did everybody start from? Well, I would like you to invite you again. The NLC made the original mistake of hearing one side because of other reasons. Please don't make that mistake. Let us have another day, and let's have the tender back so that we can cross-examine them the way we have cross-examined these people. Then, you will, as a good judge, you will make a decision as whether there was any eviction, whether there was what we call ancestors living there, whether the land is empty, whether you will get these facts, but don't do it in the county hall. Come to the ground. Let's have this petition heard on the ground.
NLC. Is it possible to hear this matter afresh?
No.
Honorable Chair and members, when this matter was determined, when the court quashed our decision, we had a timeline of receiving historical and justice claim by September 2021. And I think the ruling, if I look at the ruling, it was in February 2025. Meaning we were not able to receive any claims by them. But now, as I've said earlier, His Excellency through because His Excellency has approved us, he has actually given us an extension of Section 15 of the National Commission Act through the wisdom of the Parliament. And we are not fully constituted. Once we are fully constituted, we can allow the members, the parties to submit the claims again. Then relook at it.
Now, without waiting for the petitioners, can NLC, once the commission is properly constituted, can you, on your own volition, begin the process of settling this matter, or rather finding out? Yes?
Maybe Chair, just sorry to interject, but looking at the ruling, number 339, if you look, there was no claim of historical land justice that was ever repeated to facilitate a lawful hearing and determination as pronounced on it. So in the court, because there is a procedure of filing a historical land justice, so maybe Chair, unless the National Land Commission started again by filing a fresh historical record to interject on that. So
Chair, allow me also to interject. I've been getting his submission from the World Group. I think it's a partisan PS. Because even these people are involved in this dispute. We need to get somebody who can be neutral. Because the Maasais, the Kulia, the Kipsigis are Kenyans. There's a PS for this country, Mr. Chair. I think it's not right.
Chair, I think you need to protect me, Chair.
I hereby protect you, PS. Yes.
Because, Chair, you invited me to make submissions on the factual position that we have, unless you want me to lie to you, Honorable Chair.
Yeah. And on that, I am in agreement with you, Honorable PS.
Chair, can you give me a...
Yes, Honorable Mark Nevitan.
Chair, I think we are proceeding very well, and just one of your committee members asked about friends of the committee. And I think when we've been admitted, we are actually part of the committee. We check the standing orders. So we actually have just a right to participate just as a members, just to help my good friend engineer. But Chair, listening to Sonkuli, I think he's right. On the issue of fair administration of justice, I think it would do good if this committee invite all the affected stakeholders. So because the claim is between the Tende and the Moyoi community, I think I want to request that you give the Moyoi community an opportunity to also come and make formal submissions, even if they don't request themselves, so that before you compile your final report, it is actually captured. But also on Sunkuli's point, Chair, maybe he should know that the wisdom behind forming the petitions committee was to listen to the members of public in any case where they think that they have a rightful claim and they have not been heard. And this is a house of the people, including where court rulings are against them and they feel that they have not been fully heard. So coming to this committee and saying that the court has ruled competent jurisdiction, this committee has a right to to hear, because we represent the people, and that is actually the wisdom of forming this committee. So coming here to say that, you know, the court has made a decision, there's nothing we're discussing, is actually out of order. But Chair, there are very many issues that have not been, and allow me to say that, you know, the National Lands Commission is cutting corners. Your questions were very specific. The first question, the letters that you sent to the Moyoi community, who? Give us the name of the institution or the person who received them. And if you don't have them, you tell us that this is exactly what you did. Don't tell us generally what the commission does and things like that. Number two, when you actually send a letter and people fail to appear, what are the options of you summoning? What are the options that you have at your disposal in terms of service and even summoning? Did you explore that? That is number one. Number two, was there, and I think that was asked, I think, by the Vice Chair, which is a question you've not answered. On the 20,000 acre piece of land that was unoccupied, was it your finding that there was a 20,000 acre piece of land that was unoccupied, based on the documents that were presented, based on your visits to the ground, and based on all the other things that maybe you might have had access to? And that really requires a specific answer. But Chair, to help you, even as you will be retreating to do your conclusion now with your own committee, after you've listened to all this, I want to enable also this committee know who exactly are the people around there. Can we, because we have the National Land Commission and we have the Ministry of Lands, I want to ask the committee to request that the list of owners of land on the disputed parcel of land, the Moyoi, everyone else, every single person who owns a title, so that everyone will get, because the next time you'll invite the Moyoi here, and then maybe someone else will say, I am also a stakeholder and I was not invited, and we'll be going round and round and round. So since here, and I request that Chair that you rule that the Ministry of Lands do provide us with a full list of adjudication. Who owns land on this disputed land as we speak? Because that, I think, will answer some of your questions. That will answer some of your very critical questions that actually are here. So that even as you listen to people beyond the ones who are in this room and the ones you want to invite, can the Land Commission and the Ministry of Lands provide us with a full list, complete list, including the ones who own a quarter acre of the whole?
I asked NLC when they made their examination, what did they consider to know that, to be